Hello everyone, welcome to the channel Learn Law with Professor Rashmi. So today I am going to start with series of one important subject in law, that is Indian Contract Act 1872 or contract law. Contract law is one of the crucial subject when we talk about legal field. What is the importance of Indian Contract Act? So basically Indian Contract Act, which is now for say LLB, this year SEM 1 will be having sections 1 to 75. So this sections 1 to 75 of Indian Contract Act talk about general framework for formation of contracts. Basically what are the principles involved in formation of contracts is discussed or is given in this Indian Contract Act of 1872. Contract is one of the important part in commercial transactions, we know. So it forms a basis of mercantile or commercial law. Apart from that, contract law is also important in purview of or in respect of day-to-day transactions. So you may not be aware about it, of the fact that we enter into endless number of contracts day in and day out from morning to night. So what are these contractual transactions? Any transactions which take between the two parties for exchange of some consideration are governed by this contract law. So it is not only an important and crucial part of a commercial law or mercantile law, but it is also one of the important law with respect to the transactions that happen day in and day out in our society on regular basis. So this all would be covered under Indian Contract Act. So this is the importance of Indian Contract Act. Let me tell you, understanding this law is crucial not only from exam point of view, but also it is going to immensely benefit you when you enter into practice, may it be a corporate job or may it be in judiciary or you go into advocate practice or any damn thing. But contract law is one of the important and basic. So understanding it clearly is very important and essential. So don't take it as a subject that this is a SEM 1 subject and I have to clear it. But whenever you are going to deal with other subjects in law, contract would come in each and every subject. So keep in mind that contract law should be thorough. You should be having clear concepts about this contract law. Now let us go to the details of the act. So the short title of the act is Indian Contract Act 1872. It extends to whole of India. Earlier it was only extending to India except Jammu and Kashmir. But after the abrogation of section 370, now it is applicable in Jammu and Kashmir also. So it extends to whole of India. Act number is 9 of 1872. So it was the 9th act which was enacted in 1872. Enacted on 25th April 1872 and it is enforced or it is in force from 1st of September 1872. Now the year is 1872, which simply means that it is much more before the independence of our country. So this particular act is totally based on the British law or English law, right? Because the Britishers has enacted this act. So basically this act is taken from or it is based on English law totally. There are some deviations at some point of time. So wherever Indian law differs from English law, I am going to tell you what is the difference and how this difference is relevant in today's India also. So this is all we are going to deal in our upcoming lectures. But remember that this basic contract law is based on English law. So what is Indian contract law about? So this law is about regulating the transactions or regulating the contractual relationship between the two persons or maybe parties, corporations, government, not only natural person, it will be legal person, companies, everything. And it deals with basic aspects of contracts. So here I have written as bail, pledge, guarantees and agencies. So these form part of special contract which you would be dealing in second year. But basically sections 1 to 75 is going to deal with how the contracts are formed, how is the contracts performed, what is their enforceability and what is the breach and remedies for breach. So this is all about Indian Contract Act. Now you all know that wherever a legislation or a new law comes into existence, there is some need required. So it is a need based thing. Our society is dynamic one, it keeps on changing, we keep on evolving. So as we evolve, new and new law comes into existence. So each and every legislation comes into existence because there is some sort of need for this legislation to come into place. So what is the legislation? What was the need for Indian Contract Act? So in the beginning of human civilization, you know that there are no specific rules. Humans were just evolving. We were still in evolution stage, and then we were finding out different things. There were no proper rules and regulation framed, or society had not at all advanced. But later on, there was a barter system which came into existence, wherein people started exchanging their goods for goods. You all know what barter is. At that time, the idea of doing business started, or came into existence. So it became, as society is advancing, this business is also flourishing. So when business is flourishing, you know that there would be transaction happening between two individual or set of individuals. But since there are no fixed rules, you don't have any remedy for if any person is committing the breach. So in order for a business to operate smoothly, there is a requirement of fixed rules that should be coming into existence, and these two parties would be governing by the fixed rules, and herein the contract law legislation becomes important. So this is the need of legislation. Coming forward, we'll see what all sections are there from section 1 to 75. So section 1 to 75 talks about general provisions. Section 76 to 123. So earlier, sale of goods was also part of Indian Contract Act, but in 1930 it became a separate legislation. Section 124 to 238 talk about special contracts. So it is indemnity, guarantee, bailment, pledge, agency. All these things you are going to learn in your second year. So basically this, don't worry about this all concepts right now. Let us understand only the general provisions of contract as far as SEM 1 is concerned. At second year stage, we will cover our contract 2 lectures also. And section 239 to 266 is about partnership. So in 1932, a separate legislation for partnership came in. So basically earlier, which Indian Contract Act was from section 1 to section 266. Now Indian Contract Act consists of only section 1 to 75 sections, and then section 124 to 238. And for SEM 1, let us focus only on section 1 to 75. Also for BMS student, you will only have the general provisions of Indian Contract Act. So basically in this lecture series, we are going to deal with Contract 1, that is section 1 to section 75 of Indian Contract Act of 1872. Now what are this section 1 to 75? Let us see it in a nutshell. So section 1 talks about the introductory part and short title and all those things. Section 2 is interpretation clause, which talks about all the terms which are used in this contract law and which are applicable to contracts. Section 3 to 9 talk about proposal, communication, revocation, acceptance and all those things. Section 10 is one of the crucial part. Here all agreements are not contracts, but only those fulfilling the requirements of section 10 would become contracts is given in section 10. So based on section 10, we are going to learn section 11 to 30. So let me tell you that in our upcoming lectures, I will make it sure that section 1 to section 30, you are having it by heart, tip of your tongue. So stay tuned to the channel and stay tuned to the upcoming lectures as and when they will be coming. Section 31 to 36 talks about contingent contract. Section 37 to 55 is talking about performance of contract. So basically, once the contract is formed, I know that up to section 30, all the things are included of formation of contracts. Section 31 to 36 are talking about contingent contract and how the contract would be performed, when, in what case the contract, what would be the essence, what would be the time essence, and what would be the conditions of performance of contract. All this would be discussed in section 37 to 55. Section 56, once again an important one because it talks about doctrine of frustration. Section 57 and 58 is talking about reciprocal promises. Section 59 to 61 is again talking about debt to be discharged, or popularly known as Clayton's rule. Now this is one of the important and favorite question, and this comes in exam, so it mostly comes as a short note. So Clayton's rule, section 59 to 61. Section 62 to 67 talks about discharge of contract. So contract is formed, performance is done. So discharge, there are different ways of the contract being discharged. So we'll discuss it there only. Section 68 to 72 talks about quasi-contract, yet another important topic from exam point of view. And quasi-contracts means all those contracts which are not officially entered contracts, but the transactions resemble to be a contract, and therefore they are given an acknowledgement, or they are given an acceptance under this contract law. Section 73 to 75 talks about remedies of breach of contract. So person who is not, so suppose I have purchased a particular, I have promised to purchase a particular thing from you, and I have already made a payment and you are not giving that particular thing to me. So this is known as breach. So you are not performing your part. So the remedies of breach are discussed in section 73 to 75. This is all about contract 1 to 75 nutshell. Now let's go to interpretation clause, that is section 2. Now section 2 is one of the important and concept clearing part, because unless and until you are clear with the concept or terms which are given in section 2, understanding contract would be difficult. And once you understand these terms or concept, it would be very easy. So it's up to you. You have to be very attentive while we discuss this section 2 or interpretation clause. Now let me give one simple example. Now I want to purchase a book, say Kite Runner, and I am going to a shop and I want to purchase a book. I go to a shop, I say that I want this Khale Rosne's Kite Runner book. I am eagerly searching, I am not able to get a copy. The person at the book counter is saying that, at the shop counter is saying that yes, I have the book. So he shows me the book and I ask for the price. He says it's something 350 or 400, I don't know the exact price. And I pay for that price. I take the book copy and come home. Now this particular example is covering all the terms of this section 2. It is covering proposal, it is covering acceptance, promise, promiser, promisee, consideration, agreement, what are reciprocal promises. In this transaction, it can become a void thing or void agreement, it can actually become a contract, or it can become a voidable contract also, all those things. So this particular example, you see, we enter, so basically this was a simple transaction which happens with every one of us day in and day out, but we are not able to recognize that it is a contract, or we are not aware of the fact that it is a contract. So after this interpretation clause, I want you to do one exercise, that is, in each and every transaction where you head towards from your home to your office to your college or anywhere, you try to fit the transaction into these different terms. What was the proposal, what was the promise, what was the consideration, and all those things. But for today, since this is an introduction lecture, we'll stop here, and in next lecture we shall start with our interpretation clause, one of the important of Indian Contract Act. So see you in next lecture. Till then, stay tuned to the channel, do subscribe to the channel, and also do let me know your feedbacks in the comment section so that I can take cognizance of your feedbacks and suggestions. Thanks a lot for watching the video. Thank you once again. Bye.